Welcome back. We're happy to welcome Iaroslav Gregirchak, Deputy Business Ombudsman from Ukraine, with whom we are going to talk about alternative ways of dispute resolution between government and business. At the Business Ombudsman Council, Iaroslav leads the team of 6 investigators. He authored 7 council systemic reports focused on such challenges with quality of business environment in Ukraine as administering taxes, abuse of powers by law enforcement authorities, promotion of economic competition, getting access to electricity, combating raidership, improving customs and administrative appeal procedure. As for his background, Iaroslav is a seasoned lawyer with more than 20 years of experience in cross-border finance and merger and acquisitions, as well as a strong interest in GR and public policy, alternative dispute resolution and arbitration, and corporate governance. Iaroslav, welcome to the GR Forum.
Thank you for having me, Kostya.
Pleasure having you. Iaroslav, with you we're going to talk about alternative ways of dispute resolution. Obviously, we've been trying to bring as many positive examples of government relations as possible, but we all know any relations can break because of a conflict, of a dispute, and the way how the two parties go about the conflicts will define how they shape their relationship in the future. So the conflicts may obviously happen between governments and corporations, and we are curious to know about your activity as Deputy Business Ombudsman and the Business Ombudsman Council in general. So why it was created and how many other Central and Eastern European countries have similar institutions?
Right. The Business Ombudsman Council was created in Ukraine back in May 2015 when we became operational and we accepted our first complaint. The political momentum in Ukraine at that time was quite conducive for such experimentation. The part of the government, first of all, who possessed political will to show to the external world, to domestic businesses, that it's genuine in its intentions to improve access of businesses to a fair, speedy manner of resolving various types of problems with public authorities. Particularly given the fact that in Ukraine we traditionally have a significant level of distrust towards courts. So that's why the Business Ombudsman was created back then. At the end of May this year, we will have 6th anniversary of our operational activity. Since then, we have accepted, we have received actually more than 8,500 complaints. And we secured for business direct financial impact nearing 19 million hryvnias, which is some 600 million euros. We operate on the basis of our reputational leverage, which stems from the fact who set us up, which is the government of Ukraine, EBRD, OECD, and 5 large local business associations. Yeah, we are not vested with any binding authority, and our main way to react towards those instances that create pressure on businesses who are unfair vis-a-vis business by issuing recommendations which are taken quite seriously. We so far issued more than 3,700 of such recommendations. We call them individual recommendations, and believe it or not, but the success ratio, the percentage of those individual recommendations that has actually been implemented in practice by all of the Ukrainian public authorities exceeds 90%, which is an absolutely staggering, wonderful figure, which proves, among other things, that indeed, if in the conditions of a Central Eastern European jurisdictions like Ukraine, you structure reputational leverage right, and this just proves how important is the inception stage, then the mechanism can bring wonderful results, probably even better than the conventional dispute resolution mechanism. The approach has indeed been followed in the selected Central and Eastern European countries like Georgia, like Poland, where they have specialized SME ombudsman operating under the auspices of their Ministry of Economy. Nonetheless, in both of those countries, these are governmental agencies. Specifically, this is the part of the structure of the public authorities in the true sense of that word. In Ukraine, however, the unique approach is that we are a multi-stakeholder instrument. We involve the government as one of our founding fathers. However, we are not a public authority in the true sense of this word, even though I was appointed to my role by the resolution of the Cabinet of Ministers. However, I am not a public official, and it kind of brings in this good element of our structural independence, which enables us to be so successful in our operational activity.
Yeah, thank you, Iaroslav. I think your role in between government and businesses makes you kind of an agent or a lobbyist of the corporation interest within the government, which is part of our government relations profession. But speaking about what you said about distrust in the Ukrainian court system, which may be also the case in some other countries of the region, more or less, how efficient is your mechanism of dispute resolution compared to the traditional court systems in the countries like Ukraine and as well as in other countries that you have already mentioned?
Let me ask you to your question in the following way. Yes, indeed, one of the main incentives which prompted creation of our institution in Ukraine is effectively problems with courts or with the rule of law. However, I would argue that even for those countries in CEE region where the rule of law is far more better observed than in Ukraine, the instrument that I represent possesses certain structural institutional elements that are worth being replicated everywhere. It's bound to be useful for business regardless of how developed and law-abiding is the jurisdiction in which the particular business operates. And I would like to give you a few reasons for this point that I made. First is that our services are free of charge and far more faster than the type of interaction you can expect if you lodged a lawsuit with the court. That's the first. Second is that, and it's quite important, if you were to look at the definition of the business malpractice in our rules of the procedure, you will notice that you are entitled to lodge a complaint with us to challenge any instance, any decision, inaction, or action of a public authority, which is not only illegitimate in the sense that this is openly breaking law, but also instances which prove that the manner in which the business is treated is unfair. In that sense, our mandate is much more broader than what administrative courts are traditionally doing in our region. Because often you might lodge a lawsuit and you will not even have this to be accepted into consideration based on the grounds that, well, the manner in which the impact was caused was the result of the discretion that the particular public authority is vested with. So on its face, it's legitimate. So there is nothing to litigate about. So this is not a litigious circumstances. And this is true for Ukraine, for sure. In our case, however, if you were to lodge the complaint with us, you will get a sort of a broader view on the interpretation of what your problem is. I can give you a few examples of those instances. The launching of criminal proceeding. Yeah, the pressure inflicted by law enforcers is an unfortunate phenomena suffered by some businesses in Ukraine. Well, the mere fact of the criminal proceeding being launched is not illegitimate. It's not illegal. But it might be really unfair for business, particularly for publicly traded companies that are obliged to report such information, and which might be negatively perceived by shareholders and or investors and or stakeholders. Another example is, let's say, the situation on the border. You have fast deteriorating goods which needs to be cleared through customs faster, because otherwise they will just simply be lost. And even though the terms are not yet been breached by customs, you can lodge a complaint with us in an attempt to ensure that this will happen in a manner which will not be detrimental to your situation as the importer. Another example is the situation right now when the businesses are in the circumstances of a moratorium. On the one hand, moratorium in Ukraine, at least, does not allow controlling authorities to conduct their audits. Tax authorities, for instance, are not entitled to come over and conduct the regular tax audit. But on the other hand, in Ukraine, moratorium also imposed the restriction on the tax authorities' ability to consider businesses' complaints through the procedure of administrative appeal. Some businesses are suffering from that because they would like to challenge their merits in a pre-trial manner by employing this administrative appeal mechanism in order to, among other things, rescind apparently illicit decisions of the tax authorities adopted at the lower level. And sometimes we succeed in convincing, and we have succeeded, I mean, during the last year in convincing tax authorities that, no, guys, we shall really hold that hearing in the online regime, more or less in the same way as we are communicating right now, and achieve the positive result. These are just a few examples of the scenario which proves that our mandate is inherently broader than the one possessed by courts. Third important pillar that explains why we are interesting for the overall element, as one of the elements of the overall GL strategy, perhaps, right, is the principles which we employ, which determine our operational activity. This is independence, impartiality, but also confidentiality. For many businesses, the aspect of confidentiality, and I assume this might have been mentioned during the course of this wonderful online forum, Konstantin. Sometimes, as a GR professional, you play with confidentiality both ways. You are either really treating the matter very discreetly. You don't want the world to know about any problems that you are facing, which is pretty much not uncommon for a traditional business approach. And the level of confidentiality that we offer is uncomparable to the one that you might inadvertently get yourself exposed to if you were to lodge the lawsuit with the court, because the latter are much more, circumstances much more prone for your problem to become known public, which is something that you really want to avoid. Having lodged a complaint with us, however, the default approach that we employ is that if I am approached by the media, for instance, I am not even entitled to comment on whether the particular complainant has even approached with a complaint with us. So the threshold is very high.
Thank you very much for this answer. Do you want to add something?
Just a couple of things. They're quite important, Konstantin. On the other hand, you can play confidentiality a different way by having us involved. You can abandon it, and if you want to make things public, you can make a press release that we see from time to time from businesses who are really sharing with the entire world the fact that they lodged complaint with us. So they are trying to bring more attention to the fact that they feel that their interest has been aggravated, and they feel that this is important to draw everyone's attention that the business-ombudsman has become involved. And the last thing is that there is a good nexus between what we are doing and what could be the next step, which is to go to court. There is a good nexus. And what I mean by that is that even in those circumstances when we have not succeeded in helping out our complainants in a pre-trial manner by exercising our mandate, we finalize our investigation with the decision of the business ombudsman, where the position of the business ombudsman council on the merits is really expressed in that document. And that document basically serves as the good piece of evidentiary base that the complainant is free to show to the eyes of the administrative judge. And since we're talking about the institution which is on the market, so to say, for the 6th year, the general perception from the judges is quite favorable, equal to the opinion that is typically attributed to the respectable expert or authority.
Thank you for this important point. So I understand the range of your responsibilities and also the independence that you have gives you a great room to navigate in serving the interests of your complainants. Knowing about the confidentiality that you have, we are still eager to learn about some specific examples of your work that you're ready to make public, and or that those that you're ready to partially disclose without naming the companies, the specific details that would make us guess who those complaints were. But those specific cases are important for us, for the audience, to learn what your institution is capable of delivering.
Right. Did Olesya Olenitska from Metro Cash and Carry confess in course of this forum that they have approached us a couple of years ago? Because apparently they made this information public.
Yeah, she actually spoke about her cases, and she mentioned that she referred to every possible means of support to, you know, to secure a public opinion in support of some of the draft laws that she was trying to pass. I believe she mentioned you among one of the institutions that she referred to.
The reason I'm asking, Konstantin, is because indeed I think I'm free to mention those cases that has been made public by the complainants themselves. So I'm not breaching any confidentiality here. Yeah, in terms of those cases where the direct financial impact is most visible, it's most obvious and the easier to show, actually the case of Metro Cash and Carry was or is topping our list with 2.3 billion hryvnias, which was the amount of fine that we helped to rescind, and it was as it was alleged by the tax authorities that this supermarket wholesale trader has reportedly breached some rules dealing with administration of cash that they collect there at the premises. The amount of fine was 5 times multiplicator of their turnover, and this is the amount that we helped to rescind. It has been cancelled. Another public matter that I think many GR professionals might have heard about is the circumstances which dates back to December 2018, when we've been instrumental in assisting Philip Morris to have the Cabinet of Ministers of Ukraine to approve the draft, the resolution which enabled the head of Ukrainian tax authority at that time to enter into the settlement agreement with Philip Morris, which enabled this well-known company to avoid the need to pay significant fines for the alleged breach of the customs/tax regime connected with the manner in which they've been producing cigarettes with reliance on the Ukrainian tolling scheme. You import, manufacture, and you export. We have helped Philip Morris to avoid paying. We reported more than 400 million hryvnias of the direct financial impact for them. A big metallurgical investor has also been fined to the tune of 350 million hryvnias. We also got involved, opined, and allowed for the rescission of this fine. So naturally, most of the direct financial impact related successes, they come from the tax sphere for the obvious reasons. But there are some other, cases. For instance, there has been this relatively famous situation involving Racket Bekinze, also the case that has been made public, which dates back, I think, to 2017 or 18, when they had problems in re-registering strepsils, something that we see in our aptekas in Central and Eastern Europe. They really had to re-register its certification with the Ukrainian Ministry of Health as the medical drug. And they've been effectively prevented from doing that because all of the underlying documentation that they were supposed to lodge has been previously arrested by the law enforcers. We helped them by liaising directly with the general prosecutor of Ukraine in order to tackle that situation. He even personally apologized to this investor. There are circumstances with famous agricultural commodity traders who at that time, when they are about to export goods, grain, corn, some types of oil from Ukraine, as a matter of Ukrainian law, this is the situation when this value-added circle related to VAT administration ends. So exporter is entitled to receive VAT refund. It's not infrequent that tax authorities might deny the refund, arguing that, look, your tax credit that you has acquired by purchasing your commodities from your seller is not fully legitimate because your seller itself, when it was buying and accumulating goods for you, has entered some fraudulent or illegitimate transactions with risky parties. We are regularly helping several of those very famous agricultural commodity traders active in Ukraine in sorting out that problem. What else? From some other fields, the famous pharmaceutical company argued that they have a non-commercial representative office rather than commercial one, and all of the allegations of the tax authority to make them an ordinary payer of the corporate income tax are legitimate. And we helped the pharmaceutical company in this situation as well to restore the fair state of play. Some investors are facing problems, let's say, with the labor safety inspection. The writ has been issued recently with respect to one of the French investors, and the implications of this writ was quite significant because it could have stopped the operational activity of the several plants, as far as I understand. We helped to rescind such a writ. We helped some investors in the renewable field to receive approval of their technical design documentation from the various types of local authorities, oblast, city councils. We helped to receive permits for the exploitation of raw materials. Konstantin, name it. We helped to rescind sanctions imposed due to the alleged breach of the currency control regulations when the fines used to be in place. Basically, you supply something and you are supposed to receive payment back in the foreign currency within 90 or 180 days. And if you fail to do so, not only you are suffering from that, but you are exposed to some penalties, which has been exposed. And at that time, when this regime was applicable, we helped many times. Raidership situations, when you got to approach the Ministry of Justice and cancel some registration actions where the attack is orchestrated against your corporate rights or against your property that as a foreign investor you own in Ukraine. basically the number of scenarios is endless in a way. We are of an institution that is operating on the national level and have so far seen it all, I would say.
Thank you very much for bringing so many examples. I'm sure you can go for hours and hours naming almost all of those 850 complaints that you have received. I see you have such a good memory.
700, yeah.
But since we have a limited time, I want to give you, I want to ask you our last question, which is, I think, also important for the GR professionals watching us across the region. For you as an alternative dispute resolution expert, what are the other means of alternative dispute resolutions across the region that you can suggest to GR professionals, where, especially in the countries where Business Ombudsman Council is not present?
Right. So let's assume, for the purposes of answering your question, that anything else beyond the traditional is not courts. Yeah. The only traditional, so to say, going to court. I do not quite believe in mediation with public authorities, because mediation is effective in circumstances when parties are equal vis-a-vis each other. So in a commercial situation, that's the good way to resolve your disputes with your commercial partner. Probably not in the context of dealing with public authorities. But you have to be creative in orchestrating those mediatory circumstances. The existence of the institutional framework that would enable it, namely the institution like ours, is good. Is a good precondition for employing this type of practice. Another technique that is not cheap, but is on an increasing scale, is what's called investment treaty arbitration. Is when if you are a foreign investor, you are entitled to sue the host country due to the alleged breach of fair and equitable treatment, let's say standards foreseen in the bilateral investment treaty between the country where you are originally from and the host country. It can be also Energy Charter Treaty as a multilateral instrument. And so, sorry for sounding too legalistic here. So you can also do that, and even in Ukraine, if in order to do that, you have to launch the procedure by filing the notice of dispute, where you basically express your intention to eventually sue the state unless the matter is settled. And those BITs, they foreseen from 3 to 6 to 9 months, so-called cooling off period. And during that period of time, you're entitled to enter into negotiations with the state in an attempt to seek amicable resolution or settlement. In Ukraine, we do this under the framework of intergovernmental working group that Ministry of Justice is obliged to create. In other countries, the approach might be similar, might be even absent, but still this is another venue for defending your interest if you're a foreign investor in a particular state. Another way, and we are about to introduce this in Ukraine as well properly, we are one of the few Central Eastern European jurisdictions that lacks it. Prior to going to court, sometimes you're even obliged to lodge an administrative appeal, which is to exercise a certain platform that each ministry, each subnational government has to create in order to enable to hear your case in a pre-trial manner. It's called administrative appeal. So this is another manner for you to try to cure the situation.
Iaroslav, I want to thank you very much for your contribution to the GR Forum. I was curious to learn about all those examples where you were able to help foreign investors and other companies in Ukraine to protect their investments and actually make Ukraine a better place for international investments. Keep up the good work, and I hope the other countries in the region which do not have such an institution will soon take example of Ukraine and also establish some additional mechanisms for alternative dispute resolution. Thank you very much again. Have a great weekend ahead.
Thank you very much, Konstantin. Indeed, ombudsman mechanism is one of the important pillars of any GR strategy when it comes to defending the interest. Thank you, and likewise to you, good weekend there.